You're listening to the Valley Current.
So I'm going to take the liberty here, at least under fair use and, section whatever, 107 of the Copyright Act, and let Lynn analyze this. And you're going to see what happens here, which is that literally the next thing they do is show you this activity bar. Like, there's no lawyer that can read this document that fast, right? The way the activity bar is saying, now I'm analyzing, now I'm doing this, now I'm doing that. And by the way, if you don't like how long it's taking, there's a button here that says I could email you the results if you want, right? So you can get an email. Of course, they then have your email address, which means you're going to get a lot of marketing stuff, right? And then they start giving you like some of the details of what they're doing as though they're a live human being doing it, right? I'm analyzing this, I'm analyzing that. And this represents kind of what's in the underlying AI program that's doing the analysis, right? Because there's not a human being. Arnold is not in the background quickly reading this. There's no human being doing this, right? Unless it's Theranos, maybe then there's some fraud going on in the background, right? That's what Theranos did, right? They said, oh, we have this automation system, but in fact, they had human beings, doing other things in the background. So, by the way, the stuff that's coming up is not a bad checklist of what you would do as a human being. Like, start with what's the governing law and look at what law are you under, because technically, what gives you the right to interpret a Delaware law? You're not licensed in Delaware. I'm not licensed in Delaware. Like, all right, so look at what comes back. This was all in real time. I'm not touching the keypad here, right? You should not sign. I'm 100% confident that you should not sign. Please do not sign this document. It has too many errors. I strongly recommend you to contact, I don't think the English is good. I strongly recommend you to contact a lawyer to get a human review. Now, that may help in the unauthorized practice of law, right?
This is a shill for Arnold. This is just a shelf to get that other dude business.
But your argument is, wait a minute, is he practicing law in the United States under Delaware law, under California law? Like, wouldn't they have to say,
he is.
Right? Arnold is not licensed in any of these places, right?
Of course he is, yeah.
Right? Yeah. So they have a button here that says get human review. We're not going to do that because that's going to go to a paywall, and the paywall is going to ask for the 99 euros. So we're going to enter lawyer mode. Even calling it lawyer mode is weird, because is it lawyer mode as in they're the lawyer and now you're the client and they're in lawyer mode with you? Or is it more like you're the lawyer using us and you're like your own lawyer because you're not using really our lawyer, the human review? Like, these buttons, if you're trying to avoid the state bar from, bringing a criminal charge of, I don't know if it's a misdemeanor or what it is, probably in Florida, it's a felony. Everything in Florida is a felony. In California, I think it's a little lighter. I mean, California, you could steal $3 million and get away with a plea. I mean, that's crazy. In Florida, these people would be in jail for like 20 years each. Easy. All right, so enter lawyer mode, right? Deal breakers. I mean, that's really interesting to go that far. 1 fatal error, 2 warnings, and 3 notices. And this is where actually you might say they have a nice user interface. The definition of what's confidential is very limited. Only stuff explicitly marked as confidential. That's good in a mutual situation. You both need to be on the alert. The NDA does not specify, this is what they're saying the deal breaker is, I think. The NDA does not specify security obligations for protecting the confidential information. That's too much of a risk. If something leaks, the court will try to determine implicit degree of care, and you don't want courts to figure out security obligations. So they literally want the NDA to say, you're going to store this information in a password protected manner, at least as secure as you protect your own trade secrets and confidence, or some other language they were looking for that wasn't there. And then the other warning, because remember, there were 2 warnings, 1 fatal error. Why they didn't put the fatal error first, like why it's in the middle, is beyond me. Like, if you're putting if you're following the logic, 1 fatal error, 2 warnings, 3 notices, it would be the X first and then the 2 exclamation points. They put it in this different order. I don't know why. There's no explicit IP clause in this agreement. And then they say it's not really necessary, but consider adding one to avoid discussions, especially over derivative information. There's actually a very important subtle point there that she's pointing out. I'm calling it a she, that the machine is pointing out, which is what happens if there's actually co-creation in the course of the discussions between ZAP and FYO, ZAP and FYO, and a new idea emerges for some new type of helmet that includes both the visual and the audio. Who owns that co-created intellectual property? Who owns that? That's kind of what's being hinted at here, that there's no real discussion of how derivative works or derivations of the exchange data. I mean, we all know from just the brainstorming we do that there's a form of co-creation that occurs, and sometimes that becomes leverageable into the future. And then there's 3 notices. The definition of what's confidential is pretty much standard. I don't know how you could say that without knowing Delaware law and what's standard under Delaware law. There's no explicit non-solicitation clause. Well, we know in California, non-solicitation clauses are problematic. I don't know about Delaware. Maybe Delaware it's not. There's no explicit limitation of liability clause. That's not a problem. That's a pretty bold statement. Maybe that is a problem, right? Maybe that could be, from a client point of view, a problem here. I mean, I know non-disclosure agreements that have limitations of liability. And now, so let's flip down, unless there are questions about the deal breakers. I don't know why this is plural deal breakers. Maybe the ones on the left are sort of all deal breakers. Then there's other issues to pay attention to. So they're bifurcating the user's attention around, well, we give you the really important stuff first, and now we're going to give you kind of the rest of it, right? So what's your reaction to this, Joe and Kim and Christy? Because this is indirectly where a lot of law work is going, which is, I want to get my spend under control. If I can use some automation, then I'm going to use automation. And believe me, this is going to eventually get even into the realm of litigation. This is obviously transactional, and it's a corporate type document or a standard corporate type document. But this is headed in the direction of litigation documents as well. It's going to get there. It may take longer to get there, but it's going to get there. What's your reaction?
I don't know how this can happen unless the laws change.
Because of the unauthorized practice of law, right?
Absolutely. I mean, I wouldn't want to use this and somebody found out. I'd get charged with aiding and abetting the unauthorized practice of law.
Oh, I hadn't even thought of that. Oh, man, that's funny, because there is an argument. I mean, my first observation is there is an argument that for someone who's a new lawyer, even just getting some helpful hints from the automation of what should I look at more carefully is helpful if it saves some time. Like, it's a checklist. Now, instead of using a checklist with a piece of paper, traditional checklist as a piece of paper, and you have the document here and the checklist here, and you compare them, this is an automated checklist. And it's got sort of a human-like bot that's spitting out, hey, I've gone through my checklist and this is what I found. Now you go through your checklist. What's your reaction to that? Because I tell you, I think there is an argument that if you did a head-to-head comparison between giving the document cold to one lawyer and giving the document with Lynn to another lawyer, equal competence among the lawyers, equal experience among the lawyers, and you set a timer, and I think they actually did this recently. They did a white paper on this. The lawyer with Lynn will do the work in 2/3 less the time. So if it takes the lawyer without Lynn an hour, it takes the lawyer with Lynn 20 minutes. And
what's the competence level of the lawyer?
Similar, 10 years. Call it 10 years of reading this sort of poop.
In the study, it's actually 10 years.
Yeah, I'll show you.
I don't believe that.
Yeah, there was a YouTube one. I'll find it for the next meeting. There was an actual YouTube where they actually filmed the lawyer with Lynn versus the lawyer without Lynn. 2 different lawyers, both graduated from the same law class. fundamentally were very similar lawyers. At least that's what it looked like. Because this is like the beginning of issue spotting. This is like, how do I get some issue spotting going? Because this is what the bar exam does to some degree. It says, have you're competent enough to see the issue? And can you at least identify the issue? And can you at least argue the pros and cons of an issue in some semi-persuasive way?
Yeah, but you should do that by reading the agreement.
Well, you're a traditionalist. I mean, I agree with you that that's a traditional approach. But you know what? There are lawyers that won't pick up. Blake Stafford is one of them. Won't pick up a keyboard. Like when people said you're gonna have to have a computer on your desk, he was like, "That's for a secretary. I'm not doing that." And I think right up to the day that he left the firm, he had a secretary, a full-time secretary, and did not. I mean, he may have pecked a key to read an email, but he wouldn't reply to emails. He dictated a reply through his secretary. And I think Craycroft was very similar to that. To just remember a few people that were like, I'm not touching a keypad. That's secretarial work. I'm not doing it.
Well, I'm not saying, that. I am very, as far as using my tools that are available to me, I'm very adept at doing that. But this is something entirely different. I mean, you're asking me to trust a computer to do my job.
We touched a nerve here. Wow.
This is the way I look at it. I mean, it's ultimately going to depend on how good this is, right? How well it performs. Because, I mean, take this example. If there's a business person who can't afford a lawyer, then that person would be better off using this as opposed to nothing.
Every startup wants to control legal spend. They didn't have money for legal spend. We had to do a deal with them. But I think where it might be more useful if it gets to be good, if it turns out to be a pretty good program, is to have it as a lawyer's tool, so that, like you say, rather than just read something from scratch and take the time to do that, you pitch it through this. All this stuff comes up, and then you sort through it and say, okay, well, what about that? What about this? And then if that does cut down your spend, it could cut down, the amount you bill a client. And maybe as time goes on, if you rely on these things and they're relatively good, as long as you rely on them reasonably, that would cut against malpractice too. Right. But Arnold won't get any money that way if you do it that way. Right.
Well, sure you will.
How's Arnold getting?
Well, I mean, if Arnold was a California lawyer, he would. Right. Right.
Maybe. Maybe.
No. Well, but let me posit what I mean. In other words, if this were more of a B2B tool, in other words, sort of like you sell this to the lawyer, you don't try to go directly to the lawyer's customers. You sell it to the lawyer to better serve his customers.
Right.
So because it can be, if it's good, and again, I mean, I have no idea how good this analysis is on the screen, but if it turns out that it does pretty good work, it's just that it can't, come up with everything because it's just, there's going to be limits to it. If you could rely on it, it could really cut down it could cut down the amount of time you have to spend to give the client advice, which could make it cheaper for the client, assuming that the cost of this is relatively reasonable.
Right. I think that lawyers are generally reluctant to use tools like this, because they typically think there's nuance in wording that, even good lawyers don't catch until the litigation crucible smashes the language around. So imagining that a computer is going to pick up that nuance, like there's something in the news yesterday or today about some 100-year-old U.S. Supreme Court case that had a typo where the word properly was misspelled as property. And it got cited many, many times for a legal principle that was never really enunciated because the typo was fixed, but people found the published version of the book because the errors were not updated in the computers because there weren't computers. It's like a 100-year-old case that made it into the published book. So the published book still says there's a fundamental right to property, which really was supposed to mean to properly something, whatever. Like there's a famous story. I'll try to find it and circulate because it's an example of just one word can make a big difference. So let me just show you. So this stuff is going to be controversial for sure, but it's starting to happen, and it's starting to happen in ways that clients are becoming savvy to. So of course, their view is, what are you doing in the way of automation to try to, like they want project fees, like that's fundamental. They want a fixed fee. They would like to say, every case has a fixed fee. Small employment case, I don't know, they probably would say something like $50,000, soup to nuts. You try it, you do the appeal, everything, 50K. We'll give you all of our employment cases. There are probably firms that do those deals. I don't know, 50K, but basically some number per case. And they basically say, we'll do every case and we'll handle every case for you for that fixed project fee. You have to give us at least 20 cases a year or some magic number. Now, I don't know what actually happens, but certainly you don't do multiple writs. You don't do a lot of the stuff that John wants to do. You basically say, you're going to do minimal discovery, then you're going to try the case, or summary judgment, and then you're going to try the case.
Yeah, that puts ethical, raises ethical problems though, right? Especially if once you take the fixed fee, the client's saying you're not doing enough.
Right.
I mean, what you have to do is and I've seen contracts like this before from law firms. You have to just paper it up one side and down the other as to what you're going to do and what you're not going to do. And then if stuff, gets, the surprises come up, there's a mechanism for working with the client to try to get additional money and all that. I mean, I suppose if it were simple cases, you could do it, and you got a bunch of them, you could probably do it and, be relatively confident. But the more complicated the case is, the more difficult it becomes to predict what the time you're actually going to spend, because some of it is dependent on opposing counsel in the courts. So, the more cookie cutter the case is, like a bankruptcy filing or something like that. Right. I know in the patent prosecution realm, there's always, for a long, long time, there's been this commodity push to, have the applications done for a fixed fee. But, once the more complicated the service, the tougher. I mean, I can't imagine doing patent cases on a fixed fee. And I don't think very many people do them unless they're troll cases that you assume are going to get settled, for $50,000 or whatever within a year. Then I know there's some people that have done fixed fees on that, but you just couldn't do it with big patent cases. And I mean, unless you just were, I guess, desperate and you just figured I got so much excess capacity that I'm going to just do it and take whatever money I get. And if it comes out that I'm earning $100 an hour, then I'm earning $100 an hour.
Well, there are lawyers that are doing IPRs, which are these patent office invalidity challenges, right? That sometimes are done in parallel with litigation where a stay is entered. Sometimes they're done just before even a litigation is filed. And that's become a big business. And there are firms competing for project fees to bring those IPRs. Right.
But discovery is so constrained in those.
Right.
I mean,
it's very minimal.
Extremely constrained. And, there's a schedule set in it. Everything has got to get done within 18 months now, is it? I think that's the outside. Is it a year? I can't. Kim,
I think it's a year, but I could be wrong.
I think it's. I think it's a year, and so that's a good example, Jack. Actually, because there's so many constraints on what can happen there, and what the other side could try to do to make it more complicated, or the PTAB, not the court, but the PTAB. That's a good example. And so if you get good at those and you pretty much know exactly what's going to happen and you make the the flat fee big enough, like, $250,000 or 300 or 400 or whatever, then yeah, I think you could do it in that. But that's so different than normal district court litigation.
Well, yeah, because everybody's constrained.
Everybody's constrained.
The
right.
PTAB's constrained. The lawyers are constrained. Everybody's constrained.
Right. In district court, nobody's constrained.
Right.
Really, when it comes right down to it.
Right.
Nobody's constrained.
Look, this is where essentially you end up defining what kind of quality of practice do you want to have. Do you want to be Southwest Airlines and have a fixed, want to get away fee for $49 that'll get you to Orlando if you're 6 months in advance, and you'll be able to go to Disneyland and so on, but you're going to be in a cattle car kind of approach without a seat. And I don't know if they allow you check bags or don't allow check bags. There's all these rules now on flying. Or do you want to be Air France with, first class service and, premium everything, and you're going to pay for it. And it's not going to be $49. It might be like $4,900. Those are two very, very different things, and two very, very different approaches. Both result in transport, but in two very different ways. And that's why different law firms are trying to figure out, like, where do they fit? Are they a boutique specialist firm with a certain expertise that justifies a premium fee? Or is it more like, we do these cases on a project fee? And I said to John's, because this whole conversation started with Joe asking, what's the fly on the wall of what happened in that meeting? I said, we don't want to be a volume project fee firm, or at least I don't want to be that. I don't think Joe or Kim or anyone on this phone line wants to be that. And I said, that's more like give all this employment stuff to your carrier, right? There's a carrier that's going to provide some defense coverage, maybe covering our fees, maybe covering some of them, I don't know. But they would be happy to appoint someone that would be probably take a very different approach and probably not listen to John at all, and probably say, John, that's nice, but I'm not doing it. My employer,
and probably give Bay money.
Well, they would say at some point, we don't see, John, the economics of this case for the carrier. And that's kind of playing into the lawyers for Bay, because the lawyers for Bay are hoping that they can rattle cages of whoever's paying the bills and not
litigation cost.
Right. So the way it works, just so people know, I don't want to divert too far, is the carrier doesn't cover like the first $50K. And that's sort of meant to say, you should handle this first negotiation as best you can. And if you really don't get there, then we come into the picture. And usually the weird part for the carrier at that point in time, there's already been $50K put into the deal. And so it's hard to switch lawyers, right? At that point. So it's kind of an interesting problem if you think about it, because the carrier now is stuck in some ways. So let me just make the last point. So let me just tell you, I think that the world is headed for new lawyers in this direction. And we're all going to have to get used to it, even as old lawyers, where there is some legal tech that may be helpful, and then you have to decide how helpful it is. So I'm going to show you what I did with this data, because this is what I said to the client. And I did review the document, and you might say maybe sort of a read out loud approach makes sense in this area. So let me switch to the page that has what I did, because there actually is kind of a business point wrapped up in this that you have to think about with the client. Man, they should make this a lot easier, given should have like a one button that recognizes you've been on a previous page. So remember, the client gives this to me sort of with carte blanche, almost like, tell me whether I should sign this. The guy's already sent confidential information. He's friendly. It's cooperative. We're not antagonistic. He was probably biased in the direction of signing it, and then it was more than 2 pages, so he didn't sign it, right? So he was like, it's more than 2 pages. I'm not going to read any more of it. So I'm having a hard time getting the screen up here. So here's the email. So here's what I said to him. And you might say this email really has some knowledge in it that begins to have a bit of a checklist. And that checklist is actually sort of relevant to any review. Here's a checklist of potential changes. And the real question is whether we want to force some delay here and seeing whether there's flexibility or not, or whether there's sort of a time is of the essence, right? So I listed top 10 things, and I said the first 4 are critical. Governing law, it says Delaware, right? I thought both parties were in California, but I guess these guys are in Texas. Dispute resolution, I would use mediation, expedited arbitration, because these guys are trying to have a cooperative relationship. Does this cover only documents that are marked confidential? What about verbal discussions and so on? Standard of care, blah, blah, blah. So I list these points, right? And I say to him, do you really want me to lawyer up this NDA, or do you really want to do a light touch? Because you're really starting to define the first date between these two companies, right? They're doing a document that goes into how they view each other going forward. And I've seen a lot of relationships sour. There's a famous one involving IBM and a company that could have supplied the operating system that became what Microsoft supplied. There was a guy in Monterey, a famous lawyer named Jerry is his first name. Why I can't remember his last name now. But he gave advice to this guy that was running this company called Digital Research that had this operating system called CPM. Most people probably don't remember this. There was an operating system before MS-DOS.
I represented those guys later after that in different litigation, but it was DR-DOS, wasn't it? It was DR-DOS.
Yeah, DR-DOS, Digital Research DOS. And it was Jerry. What is Jerry's last name? He had a firm in Monterey, and he said, look, IBM wants you to sign an agreement where nothing is confidential, and you've got a lot of confidential information. I don't think you should sign it. And IBM said, F you, then we're going to go to Seattle. You're not signing our agreement, we're going to Seattle. And that's what they did. And so it was a gift. And, that guy saw the way Microsoft succeeded and his little company failed, and his company kind of got wiped out in the process. I'm trying to remember his name, that he ended up committing suicide. Or there was some story where he died relatively young. I mean, he could have been the Bill Gates. He could have been maybe the person that had the billions of dollars that Bill Gates maybe wouldn't have all the marital trouble that Bill Gates now has. But basically, he got advice from, I can't remember Jerry's last name. He's a lawyer I've known for many years, and now he's a photographer. He's retired from the practice law. He's in his 80s now. So anyway, my point is, I write this list of 10 points, and I'm asking the client because I personally think it's a mistake to over-lawyer these NDAs unless the client really is trying to send the signal that, hey, there's a lot of stuff we have that you don't have that we're really sensitive about. Because Joe asked the right question. If it's just us receiving their information, maybe you just let their document control and you just take some protective steps to make sure you don't take advantage of their stuff. But if it's our data going to them, you have to be more worried because basically there could be a loss of patent rights, trade secret rights, just a bunch of stuff. So I hope I've demonstrated enough to suggest that A, there's LegalTech on the horizon, and B, you can use it as a checklist, and C, you still have to do the work of reading the agreement, but hopefully amplified by the checklist in a way that allows you to sort of save some time and maybe do a closer comparison. And let me tell you something, there are a lot of lawyers and a lot of legal departments that spend a lot of time on these documents. And sometimes there's little hidden bombs. Like I've seen some stories where there's like non-compete language, probably illegal under California law, but might be enforceable under Delaware law. That says, for example, you'll stay out of the area of audio. That would be a big give in exchange for getting access, right? To imagine that you're now blocking the future development of the company. I mean, that would be a real problem in some ways, right? So any questions about this stuff? Because it sort of blends into the protective order discussion that we're having. Obviously, if you file the patent and the patent's issued and it's all published, then you're not talking about trade secrets, but typically you're talking about stuff that's either subject to a confidential patent application that's not been published yet, or is in the process of being turned into a patent application, or maybe is not ever going to be published and is not ever going to be subject to disclosure and is going to be kept as a trade secret, such as like the source code for DR-DOS or the source code for MS-DOS, right? I mean, those things were kept as trade secrets back then. It was even uncertain whether copyright even protected that code back in the heyday of when IBM was looking at what operating system do we want to put into our next innovation. So that's what I have on this. Are there any questions about it? We'll talk more about this automation stuff as we go forward, but for Lin Yan and other young people that are, if Max is on the line, I think he is, that are going to law school, Stephanie or others, this is the future. The future is accelerating way faster than what we've seen in the past, for sure. In my book, I mean, it went from paper books to these big terminals before it even went to desktop. And it was a relatively slow process. I want to say 20 years maybe before lawyers became really facile. And now it's really like every day is a new technology. Every day. I don't know. Did anyone know about NDA, Lynn? I probably mentioned it before a few times, but I don't know that we ever did a demonstration of it. Did anyone actually know that this existed, that this tool?
I didn't.
And it's more, there's like 100 of these, and they're all vying for essentially the attention of either corporate in-house or what's now called legal operations, which is like saying there's a group of lawyers that are inside of a company managing the flow of paper that comes in and out of the company to document relationships. And it's more like, hey, we want to fix a price and we want as much automation applied to it as we can apply to it. And that's where it's all headed. So welcome to the future. It's going to accelerate really fast.
Tune in next time on The Valley Current.